Good morning, everybody, and welcome to our HRLaw webinar. For those of you who don't know me, my name is Daisy Jones, and I'm a partner in the Employment and Immigration team here at Fox Williams. Now, a few admin points before I introduce our speakers today. The webinar is going to be recorded, and it will be made available to those who have registered but are unable to join us this morning. We're very happy to take questions on the topics under discussion today. So if you could please put these in the Q&A box rather than in the chat box, we'll aim to cover these off at the Q&A session at the end, once the speakers are all finished. If I could have the next slide, please, Bailey. So in terms of what we're going to cover today, as you'll have no doubt seen, there's a huge volume of potential changes on their way. And so what we're going to try and do is provide a whistle-stop tour through what appears to be on the horizon, focusing on some of the most critical points for employers in this new Labour government. My colleague Jo, who's an associate in the team, is going to start us off by outlining the forthcoming employment law reforms and what we know so far about what to expect and when. He's going to discuss Labour's plan to make work pay, the proviso of consultation, and what we know so far about the draft legislation to be published, touching on zero-hour contracts and flagging other pertinent topics. I'm then going to continue to expand on what we anticipate are going to be the key implications for employers, discussing the status of a worker and what the single status changes may mean. I'll then move on to talk about unfair dismissal and other day one rights, finally touching on the proposed enforcement body. I'll then hand over to my colleague Adele, who is a senior associate in the team specialising in immigration law. Adele's going to take us through the forthcoming changes on the immigration side, focusing on the move to a digital system, visitor rules, and the increase in salary thresholds. So with that, I'm going to hand over to Jo to get us started. If we could have the next slide, please, Bailey.
Thank you, Daisy, and good morning, everyone. Thank you for joining us today. As Daisy mentioned, I'm an associate in the employment team here at Fox Williams, and I'll be setting out what we expect to see in terms of employment law reform and when the government intends to deliver that reform. If we can move on to the next slide, please, Bailey. So at the end of May, Labour published its plan to make work pay, delivering a new deal for working people. This document set out its intended reform in terms of employment law. It identified a huge number of areas for reform, ranging from flexible working to maternity discrimination to sick pay and self-employed and about everything in between. But the detail within that plan is somewhat scant. Following the announcement of the election, the Labour Party published its manifesto, which simply referred back to the plan, saying that it would implement it. It didn't really include any further detail in respect of its intended reform. What we do know, however, is that the Labour government has pledged to introduce legislation in Parliament within the first 100 days of coming to power to implement the reform that it's identified. By our calculations, that takes us to the 12th of October. That obviously doesn't leave us with a great deal of time before legislation is supposed to be introduced in Parliament. And since the general election, we've heard very little in respect to the planned reform. There had been rumours that draft legislation would be published prior to summer recess, but that did not materialise. On the 12th of August, Baroness Jones of Whitchurch did confirm, however, that the government is committed to delivering the plan to make work pay in full. Ministers are identifying the most appropriate delivery mechanisms for the commitments in the plan, including an employment rights bill that will be introduced in Parliament within 100 days of taking office. Work is underway to identify and deliver measures through non-legislative and secondary legislative routes. Our working assumption, therefore, is in that the coming weeks we're expected to see publication of draft legislation and secondary legislation like regulations in order to implement the plan. There are some exceptions to this 100-day commitment, those being parental leave and the review of single worker status. The government has pledged to introduce legislation dealing with those areas of reform within the first year. The inference from those carve-outs, though, is that the other areas identified on this slide and included in the plan will form part of the legislation introduced to Parliament within the first 100 days. If we could move to the next slide, please. I'll just take us through the consultation that the government proposes to undertake. It's committed itself to a full and comprehensive consultation. It's made a point of portraying the plan as beneficial for workers, trade unions, and businesses, and has asked for input on its plans from all three. The aim of doing so is to have an inclusive policy development process and aims to foster transparency between government, businesses, and trade unions. So where are we at in terms of that consultation process? Well, in a government press release on the 14th of August, they confirmed that there had been an initial meeting between business leaders, the government, and trade unions on the new plans to make work pay. The headline of that press release had said that businesses and trade unions were working hand in hand to deliver reform. So, will the consultation continue? The indication is that it will, not least because of the government's commitment to a full and comprehensive consultation, but also because business leaders and trade unions have acknowledged the benefits of the consultation exercise. Jonathan Geldart, the director of the Institute of Directors, said, "We look forward to the start of a detailed engagement and consultation process, which will be essential to minimising the risk of unintended consequences of these reforms." And the TUC General Secretary also agreed, stating, "Today's meeting was an important chance for unions and businesses to discuss shared gains that the government's reforms will bring, and we look forward to continued close working as ministers implement their plans." It remains to be seen, however, what impact this consultation process will ultimately have on the government's planned reforms. Also, despite the positive mood music, it goes without saying that there will undoubtedly be some level of disagreement between business leaders and trade unions on how best to implement the intended reforms, or whether a reform is even appropriate, needed, or would be outweighed by the consequences of that reform. If we could move on to the next slide, please. So, what's coming down the pipeline? In the King's speech on the 17th of July, he referred to 40 prospective draft bills. Considering Labour's pledge to introduce legislation within 100 days, the question on all our lips are, where are they all? And your guess is as good as mine, but we can glean a few ideas from both the King's speech and Labour's plan to make work pay. King Charles stated that, and I'll spare you my terrible impression, "My government is committed to making work pay and will legislate to introduce a new deal for working people to ban exploitative practices and enhance employment rights." We know that a new employment rights bill will be introduced and is likely to be an expansive piece of legislation addressing many of the areas of reform identified on the earlier slide within the plan to make work pay. Picking out just a few of those areas that we expect to see in the draft legislation, starting with zero-hour contracts. As of this year, 1 million people are on this type of contract. That's an increase of over 800,000 since the millennium. The Labour Party had originally pledged to ban zero-hour contracts outright. That position has somewhat softened by the time that they published their plan to make work pay. Instead, the government has pledged to end one-sided flexibility to ensure all jobs provide a baseline level of security and predictability, banning exploitative zero-hour contracts, ensuring all workers get reasonable notice of any change in shifts or working time, with compensation that is proportionate to the notice given for any shifts cancelled or curtailed. The intention is therefore pretty plain: ensure that workers on zero-hour contracts have some certainty as to when they will be working and the hours that they will be working, to avoid their shifts being cancelled or changed on short notice, and if they are cancelled or changed on short notice, that workers will receive a level of compensation. How this will operate in practice and what effects this has on the wider casual worker economy is yet to be seen. Another area we expect to see in the draft bill is fire and rehire. This controversial practice has been a hot topic over the past few years and has recently garnered more media attention following a dispute between Tesco and its staff at its distribution centres ending up in the Supreme Court. For those unfamiliar with the term, fire and rehire refers to situations in which an employer attempts to terminate an employee's contract and then re-engage them on different terms. For obvious reasons, employees are usually resisting that practice. Labour have pledged to end fire and rehire, to reform the law to provide remedies against abuse of the practice, and to strengthen the code of conduct concerning change of employees' terms and conditions of employment. Another area we expect to see in the draft bill is relating to limitation periods to bring claims in the employment tribunal. As some of you may know, the time limit for bringing the majority of claims in the employment tribunal is 3 months. Labour is pledged to increase this from 3 months to 6 months, bringing those time limits in line with the limits for statutory redundancy and equal pay claims. Another area which has been in the press recently is the right to switch off. Labour are proposing to introduce this in response to the growth in the number of workplaces that have adopted remote and hybrid working. Labour's plan states they will bring the right to switch off so working from home does not become homes turning into 24/7 offices. Essentially, workers have the right not to engage with work correspondence outside their contracted hours, such as emails, calls, and messages. It'll be interesting to see how this operates in practice, as many employment contracts include an acknowledgement and agreement that employees may be required from time to time to work beyond their contracted hours if the business requires. It will be interesting to see how that is reconciled with this particular right. Also, will all employers be covered or only those of a certain size? And will employees be able to bring distinct claims for breaching this right, or will it simply be taken into account when the tribunal is considering an uplift in compensation for a separate claim? Another bill that's going to be introduced is an equality, race and disability bill. The King's speech stated that it was to enshrine the full right to equal pay. It's intended to make it easier for claimants from ethnic and racial minorities or claimants with disabilities to bring equal pay claims. It's also expected that the bill will include a mandatory requirement that employers with more than 250 staff must publish ethnicity and disability pay gaps, mirroring the pay gap reporting in respect of gender pay gaps. The hope is that by raising awareness of the disparity between pay, companies will consider why those gaps exist and how they might be closed. And lastly, the last piece of legislation that we pulled out of the King's speech is the pension scheme bill, which is designed to support those with private sector pensions to achieve better outcomes from their pension pots for their retirement. It's also intended to create a pensions market that focuses on consolidation and value for members, as well as encouraging investment in a wider range of assets and driving growth. The bill's measures are expected to include automatic consolidation of smaller pension pots to maximise investment, to avoid pension schemes from holding and facilitating small loss-making pots, and to also avoid people losing track of their pension pots. It's also expected to adopt the value for money framework, which requires defined contribution schemes to demonstrate they are delivering value for their members. And it's also expected to require schemes to offer differing retirement products, such as investment options, so that funds are invested for longer, continue to be invested in productive assets, thereby contributing to economic growth, and to see increased returns for members. I appreciate that has been a very rapid whistle-stop tour of the planned reform that the Labour Party intends to introduce in respect of employment law. And we've only been able to touch on a few areas, but I hope it's been useful. And I'll now be passing you back over to Daisy, who will take you through what this all means for employers.
Okay, thanks, Joe, and thanks, Bailey, for moving the slide on. Yes, so as Joe sort of talked about, the challenge that we have is at the moment, a lot of what I'm going to say is pretty speculative because we don't have the precise details in the bill. But I'm going to try and draw out some of the more likely impactful proposals for employers and talk a little bit around the implications of those. So Bailey, if I could have the next slide, please. So the first thing I want to talk around is Labour's proposals to move to a single status of worker. And the reason for that is that this is actually potentially a really seismic change in the employment law landscape. Now, at the moment in the UK, you may be familiar with our sort of reasonably complicated three-tier system around employment status. So at one end of the spectrum, we have true employees. At the other, we have the truly self-employed. And then floating somewhere in the middle, we have people we call workers. Now, there is a whole raft of case law which endeavours to assist you if you're trying to determine which category an individual falls into. And this is a determination that becomes ever more complicated with the flexible working models and gig economy that is now increasingly commonplace in the UK. But in essence, the greater the level of control held by the employing entity and the greater the level of mutuality of obligation, so that's to say, if you're told to do something, you have to do it, and you have to do it in a particular way and at a particular time, the more you move towards the employment end of the status scale. Now, from an employment perspective, these different categories of individual are really important because a person is going to have very different levels of rights and protections depending on which category they fall into. So employees, they will benefit from the greatest level of protections and statutory benefits. Workers receive a little less, and the truly self-employed have very little by way of employment type protections at all. Now, at the moment, if you fall into that middle category of worker, you are going to have the right to minimum wage, you'll have the right to holiday pay and to pension auto enrolment. But if you're in this group, you won't typically benefit from statutory sick pay, from redundancy rights, or from protection against unfair dismissal, all of which are benefits available to employees. Now, what Labour has said is that eventually it wants to abolish this three-tier system for employment status and introduce what it terms a simpler framework where people are either workers or they're self-employed. So we're going to get rid of that distinction that we currently have between employees and workers. Now, what that potentially means is that everyone who currently falls into the worker category is going to have the same employment rights as employees. And plainly, that's a really significant change, and it's one which presents a lot of additional cost and risk for employers if you have this significant group of individuals who suddenly become entitled to sick pay or redundancy pay. It might also mean that employers have a very large new population who are entitled to protection against being unfairly dismissed. So if you're looking to terminate those engagements with workers, whereas kind of at the moment you might feel reasonably relaxed in many respects around doing so, if the change comes into force, you might need to think much more carefully about your process and about the reason for termination, as well as manage the risk of unfair dismissal claims arising. On top of the employment implications, there are also potential tax consequences. At the moment, if you're a worker, so if you have that worker status, generally speaking, you're going to be taxed as self-employed. But it probably makes little sense to have two groups, i.e. what's currently your employees and your workers, who will move to an arrangement where they have identical employment rights, but different tax treatment. So there's an obvious question as to whether all new single status workers are going to be taxed as employees. Because if the answer to that is yes, this is also going to be another increase in employer costs. So obviously you'll have to factor in employer national insurance contributions in the payments that you make to that population. So I think to anyone's mind, it's really obvious this is a very complicated change to implement. In the UK, we've got significant amounts of legislation and case law, all built up around this three-tier system. So to unpick all of that and to create this, excuse me, new single status of worker is a really considerable undertaking. Accordingly, it's not necessarily that surprising that Labour's now confirmed this complexity means it doesn't plan to address this in the October bill. And as Jo has mentioned, instead is flagging it as a measure that's going to take longer to review and implement with a full and detailed consultation. So I think for kind of your perspective as employers, it's going to be a case of watching this space for a while longer. As Jo talked about, the horizon is likely to be sometime in the next year. But what it might be sensible to think about doing now is that if you're a company with a lot of individuals engaged as workers, to start to think about how you might react when those changes come into force, because at the moment it does seem like Labour are intending to introduce something along those lines, and consider if there's anything in anticipation you might want to do to mitigate against that risk. So, for example, it might be that you want to look at your worker population at the moment and see if you might want to trim it down or kind of revisit the structure around it. Of course, this isn't an immediate change, and given the other things that are happening, you may well want to sort of park it for now, but it might be something just to sort of try and introduce into your business planning over the next few months. If I could have the next slide, please, Bailey. So the second area I want to talk around is day one rights. because as I'm sure you'll have seen in the press, a really significant plank of Labour's proposals is to provide what they term basic individual rights from day one to all workers. And when they talk about these proposals, they'll talk about proposing them for all workers. So if we get this single status change that I've just been talking about, the day one rights that we're going to cover off now are likely to be rights that apply to that whole broadened population. Now, the day one right, which has perhaps garnered the most attention in the press, is this new idea of a day one protection from unfair dismissal. Now, as you may be aware, currently employees need to have at least 2 years of service before they benefit from the right not to be unfairly dismissed. And in short, what that sort of unfair dismissal protection does is require an employer to identify a fair reason and to follow a fair process in order to mitigate against the risk of unfair dismissal claims. Now, under Labour's new proposal, they're intending to make this a benefit available for everyone from day one of employment. Now, unsurprisingly, many employers have expressed quite significant concerns as to how they're going to terminate a new hire in circumstances when it very quickly becomes apparent that it's not going to work out. So, if immediately you've got to think about unfair dismissal risk, is that going to be a deterrent to growth in employment because of this new day one right? Now, Labour's answer to this, which they've set out in its plan to make work pay, and which was also reiterated in the briefing paper which accompanied the King's speech, is that they're going to ensure employers can operate probationary periods to assess new hires, albeit at the same time they've also talked about probationary periods having fair and transparent rules and processes. Now, unfortunately for us today, until we see the bill, we're not going to have clarity on how this is going to work in practice. For example, is it going to be the case that during a probationary period, you may be able to dismiss as a potentially fair reason under the unfair dismissal legislation? Or is it that employees who are in probation will be exempt from what's otherwise going to be a day one right to unfair dismissal protection? Is there going to be a less stringent process around requirements for termination during probation? However it comes into force, though, this change is likely to prompt a much more cautious and rigorous approach to recruitment because you're going to have much more limited circumstances in which you can safely and without the risk of claims terminate someone in that sort of first 2 years of employment. So you're going to be losing that grace period. And I think it's also safe to say, because you're going to have a much more expanded population of individuals with this protection from unfair dismissal, there's likely also to be an increase in tribunal litigation. Because of that sort of new benefit available for this wider population. So what you may want to do and appreciate, in terms of timing, things might be getting a little bit tight now, but if you have plans in your organisation to reduce headcount towards the end of the year, which is not uncommon, it might be that it's sensible to try and accelerate those plans if business requirements allow, so that you're in a position to exit individuals who at the moment don't have 2 years of service, and that you can do that free of unfair dismissal risk before this change comes into force. So the next thing I want to touch on is Labour's position on flexible working. So what it has said is that it's going to change the position on flexible working so that this becomes the default position for any employee from the first day of employment, unless it's not reasonably feasible. Now, the aim is that workers could benefit from flexible arrangements, such as term time options, with a particular emphasis on flexibility for workers with caring responsibilities, both for children and for elderly parents. Now, whilst we have had an increased move to flexible working, not least by the introduction of a right to request flexible working as a day one right from April, current legislation does provide that employers can refuse requests for flexible working on 8 prescribed grounds. Now, it seems that Labour's proposed change will switch the position, placing the onus on employers to make a positive case for why flexible working isn't feasible, if that is indeed your position, rather than waiting to respond to a request from the employee. Now, again, at the moment, it's not really clear how the arrangement is going to be introduced in practice, but it may, for example, involve limiting the discretion for refusing flexibility, or potentially increasing tribunal powers to review employer decisions to refuse flexible working, which at the moment are often limited to circumstances where someone brings a claim for indirect sex discrimination. So in terms of kind of a practical step to be thinking about, I'd suggest that employers want to consider very carefully how they might justify rules with limited flexibility, if that is an internal preference, beyond a general sense that people prefer office attendance or they prefer normal working hours for staff. And it might be worth thinking about kind of articulating this rationale in your job spec for roles in advance so that you're very clear with individuals from the beginning, from the outset, as to what scope there might be for flexibility and why you form that view. But again, this might depend on exactly how this measure is introduced in due course. So the final thing I just want to flag, and I appreciate on the slide it says right to switch off, but Joe's talked about that already, is I'm just going to mention kind of parental leave and family-friendly rights. So Labour's obviously said they're going to review the parental leave system within the first year, and the Employment Rights Bill is going to make parental leave a day one right. Now, again, it's not quite clear to us what Labour means when it talks about parental leave. So whether it means the kind of classic parental leave that is available at the moment, or whether it's going to be any kind of family-friendly rights. So for example, if you want to take paternity leave, that currently requires at least 6 months of service, but it seems highly likely that that requirement is going to go out. So I think, again, it's just sort of managing that sort of workforce flow and thinking about additional individuals who might benefit from more family-friendly rights from day one. And just because it's a sort of related point, something else I wanted to flag is the change in approach to redundancy. So since April of this year, women selected for redundancy have had the right to suitable alternative employment if they're pregnant, provided, of course, they've told their employer that they're pregnant, or if their expected date of childbirth was less than 18 months ago. So we've got some extended protection already for women kind of on maternity leave or about to go on maternity leave or returning from maternity leave. What we're also going to get in the Employment Rights Bill is the idea around preventing the dismissal of women returning from maternity leave altogether for 6 months after their return. Now, there is a caveat to that to say that it might be allowed in specific circumstances, but we don't really know what those specific circumstances might be. And I think the flag for all of you is to think about the kind of challenges that that might present, and the fact that it might well be kind of countercultural even for very supportive employers, because, for example, if you're having to do a redundancy exercise and someone has come back from maternity leave, if they have this protection, it might be that you actually have to select for redundancy a better performing employee because you won't be able to dismiss the person who's returned from mat leave. But again, we're going to have to watch the space to understand what the specific circumstances exception is likely to be. Okay, Bailey, could I just have the last of my slides, please? Thank you. So I'm just going to conclude by mentioning enforcement. Labour has suggested it's going to introduce a new state enforcement body to police a lot of these changes called the Fair Work Agency. And the government has basically said that this agency is going to have real teeth, because we do have other enforcement agencies at the moment and their kind of intervention is reasonably limited, but this Fair Work Agency will have real teeth. They're going to have the power to levy fines, to inspect workplaces, to lodge civil proceedings, and to bring forward prosecutions enforcing rights like holiday pay, sick pay, and parental rights, all of which Labour has pledged to strengthen. Now, given the current delays in the tribunal system, I think you can certainly see the attraction to Labour of this type of state enforcement agency, so that employers are complying with their new obligations under the proposed new Labour regime. But I think the thing to be mindful of as employers is that where you have an agency enforcing legislation or practices, often that's a much blunter instrument. Certainly when you compare it with the more careful consideration you might receive if you're subject to litigation and you have an employment tribunal judge looking at a matter. So I think what we're probably wanting to think about as a protective measure for employers is that where you are making decisions around some of these new proposals, you are very careful to create a proper audit trail and record of your decision, so that if you have an agency inspection, you're able to sort of deter any enforcement proceedings by clearly articulating sort of the basis upon which you've made decisions. I think that's going to become even more important in this new regime. And with that, I'm going to hand over to Adele to talk us through some of the immigration reforms.
Daisy. Good morning, everyone. As Daisy mentioned, I'm a senior associate in the immigration team here at Fox Williams. Today I'll be discussing some of the most relevant recent changes to immigration law for employers. However, while the Labour government has promised a fair immigration system and to reform the points-based system by linking immigration and skills policy, it's not yet introduced any significant changes of its own. Changes implemented by the previous government, however, are still in effect. Can I have the next slide, please, Bailey? The most significant and positive change being is currently in effect is the move to a digital-only system and the phasing out of physical documents to evidence right to work. As an overview, all UK employers are required to comply with prevention of illegal working guidance and carry out right to work checks on all employees on or before their first day of work. Follow-up checks should also be carried out on anyone with time-limited permission. And correctly conducting a right to work check establishes what's called a statutory excuse. That essentially means that should one of your employees turn out to not, in fact, have a right to work, for example, if their permission is withdrawn without your knowledge, or in the event that they've provided you with false documents, you'll be protected from incurring a civil penalty for illegally employing them. Whilst you're only required to check the right to work of staff under a contract of employment, service, or apprenticeship, it's also good practice to carry out right to work checks on anyone who will be working on site for you, even where they're not your direct employee. For example, agency workers or if you engage self-employed contractors. Whilst you won't technically be in breach of your obligations if you don't undertake checks on workers that are not directly employed by you, it's best to avoid the risk of the Home Office visiting your site and finding illegal workers on your premises, as it could be disruptive to your operations and risk reputational damage. So the right to work of all employees, all potential employees must be checked, and that's irrespective of their colour, nationality, ethnic or national origins, accent, or the length of time that they've been resident in the UK. You mustn't discriminate and must be consistent in how you conduct checks for all prospective employees, including British citizens. So there are 4 ways in which a right to work can be compliantly carried out, but we'll focus today on 2 because those are the ones that are essentially changing. So there's a manual right to work check where you check hard copy documents in the presence of the document holder. An online right to work check via the Home Office online system. And then the other 2 are a right to work check via a third-party identity service provider using identity document validation technology. And that only applies to British and Irish nationals with a valid passport. And via the employer checking service for those who are awaiting a decision on a submitted visa application. So as a consequence of the move to a digital system, manual right to work checks for visa holders are being phased out. And for the most part, these checks now need to be made via an online right to work check. Biometric residence permits, which are hard copy credit card sized documents which evidence UK permission, are no longer being issued to visa applicants in favour of e-visas. So from the 1st of January 2025, all biometric residence permits will be invalid, and only an e-visa will evidence right to work and the right to enter the UK. It's therefore important that visa holders ensure that they've registered for an e-visa account before that date and link it to their current passport to avoid any issues on entering the UK from the 1st of January onwards and any issues with evidencing right to work. And they should ensure that the details of their e-visa account are also kept up to date. It's also worth mentioning under the heading of right to work checks that since the 21st of June this year, the requirement to carry out follow-up checks, right to work checks on those who hold pre-settled status under the EU settlement scheme has been removed. That's likely due to the fact that pre-settled status now automatically renews and doesn't expire, or upgrades automatically to settled status depending on the holder's eligibility. Can I have the next slide, please, Bailey? So a big change for visitors this year is the rolling out of the UK Electronic Travel Authorisation Scheme. An ETA is digital permission to visit the UK and will replace the previous system, whereby certain nationals that were not required to apply for a visitor visa to the UK could simply enter the UK on their passport. Those nationals will now need to apply for an ETA before they can enter the UK. Since November last year, this applies to nationals of Bahrain, Kuwait, Oman, Qatar, Saudi Arabia, and the UAE. And more nationals will fall under scope from the 27th of November 2024, including Canada and the USA. And the final tranche of nationals will be included from the 5th of March 2025, including European nationals. An application for an ETA should typically take 3 working days to be processed, and they're valid once issued for 2 years. The application fee is just £10. Changes were also introduced to the visitor rules earlier this year. Importantly, there is now specific permission for visitors to the UK to work remotely. Visitors must not be entering the UK for the primary purpose of remote working, but are permitted to do so incidentally. For example, if they're here for tourism, to visit friends and family, or for permitted business visitor activities. This exception only applies to remote working for an overseas company, though. You can't work remotely for a UK company whilst here as a visitor. Visits of over 1 month are likely to be scrutinised, and visits of more than 90 days may lead to questions about the nature of the visitor's remote work. Additionally, previously, an employee of an overseas-based company visiting its UK branch was not permitted to carry out work directly with clients. That prohibition has now been removed, provided any client-facing activity is incidental to employment abroad and required for the delivery of a project or service by the UK branch, and not a part of a project or service that's being delivered directly to the UK client by the overseas entity. Direct client work should not be the primary purpose of the visit. And the rules for overseas lawyers visiting the UK have also been expanded, now permitting provision of legal services while in the UK as a visitor, which is very broadly defined. Bailey, can I have the next slide, please? So the previous government implemented salary threshold increases earlier this year for those applying for certain visa types. The Labour government has, in the most part, decided to keep these in place. As a very broad overview, non-UK nationals who want to come to the UK to live and work must first apply for permission from the Home Office to do so. There are a number of different immigration routes that can be applied under, and what the applicant intends to do in the UK will normally dictate which route they should apply for. The points-based system is the main route for migrants who want to come to the UK to work or study. And migrants wishing to come to the UK to work, in most cases, are required to make an application under the skilled worker category of the points-based system. Employers must hold a sponsor license and comply with sponsor duties in order to sponsor migrant workers in the UK under the skilled worker category. So in order to qualify for a skilled worker visa, the role the migrant is being sponsored to do must meet a skills and salary threshold. The salary threshold was increased on the 4th of April this year from £26,200 per year to £38,700 per year, so quite a hike. There are also salary thresholds applicable to the type of job the migrant's being sponsored to do, and they've also been increased. The salary the migrant receives must meet the higher of the general £38,700 salary threshold and the threshold that applies to the specific job type. A minimum income requirement also applies to those applying for permission as the partner of a British citizen or a settled person. Previously, the income requirement was £18,600 a year for these types of applications. However, this has also now been increased to £29,000 per year, which is over a £10,000 per year increase. This threshold was set to increase again to £34,500 later this year and £38,700 next year by the previous government. However, Labour has put this on hold until a Migration Advisory Committee review is complete. And that covers the main immigration law changes employers should be aware of that have recently come in or are soon due to take effect. And I'll pass you back to Daisy to open up the floor to questions.
Thanks very much, Adele. So we've got a few questions in the Q&A box, and obviously if people have other questions, please kind of pop them in there and we will do our best to answer them in the kind of remaining period of time. So we've got a couple of questions on sexual harassment changes, and maybe I'll just deal with that first. So We've got, as you'll probably know, in October of this year, already coming into force as a new duty on employers to take reasonable steps to prevent sexual harassment in the workplace. And that is kind of separate to the employment rights bill that's coming into force. We know kind of much more precisely what that's going to entail. And that is a new preventative duty. So you're going to have to show as an employer you have taken steps to stop sexual harassment. So that is also harassment of a sexual nature, not harassment relating to protected characteristics, from taking place in the workplace. Now, that is kind of a significant increase in the bar that we have in some respects already for employers. What Labour has said in their proposal is they're going to take it kind of to a kind of next level, if you like, and they're going to do that in a couple of ways. So as it stands at the moment, employers will discharge their duty to prevent sexual harassment if they take reasonable steps. Now, Labour want to strengthen that up a little bit, and this is a very kind of lawyerly point, insofar as they're changing that reasonable steps obligation to an all reasonable steps obligation. I'm not sure practically it's going to change much of what a lot of employers will do. That's the distinction between reasonable steps and all reasonable steps. But when we look at that as lawyers, it effectively is code for Labour saying it's a higher burden. Okay, we're going to hold you to kind of a higher standard than just a reasonable steps requirement. But practically, I think that's going to be things around looking at sort of policies and procedures, doing a kind of a risk assessment of your workplace to determine whether there's kind of risk of sexual harassment, and then putting in place measures to prevent it. And classically that's going to be kind of training, making sure people are aware of and understand kind of what's acceptable behavior in the workplace, having escalation routes available for individuals, that sort of thing. So there's probably a slight sort of strengthening of the obligation there. But in addition, the other thing that Labour has said is that they're going to extend that duty so that it's a duty on employers to prevent sexual harassment from third parties to their employees as well. So you're not only looking to control behavior of your own staff, but also third parties that might come into contact with your staff. So your kind of customers, clients, contractors that might come into the office. And that probably is kind of a more significant broadening of the duty that's already coming into force in October. So what that will probably mean you want to do or want to be thinking about is when you do your sort of risk assessment to work out where you think you're most exposed or your staff are most exposed to the risk of sexual harassment, you look at that both through the lens of your own workforce, but also the interactions they might have with clients and customers. So, do they have to do sort of client entertainment and dinners? Is there a risk of sexual harassment there? What steps might you take to prevent that? So it's a sort of general broadening in that regard. Okay. Adele, I think we've got an immigration one. Are you okay to pick that up?
Yeah. So Jessica's asked, how can non-UK citizens enter the UK to complete temporary work like meetings and business visits? So, I mean, firstly, it does depend on the nationality of the visitor. So there are some nationalities that have always needed to apply for a visitor visa before they can visit the UK, and nothing's really changing for them. They still need to do that. For those non-visa nationals that used to be able to enter the UK on just their passport, they just need to make an application for an ETA waiver, and that applies to people that are coming to the UK for meetings and business visits. Any type of visitor, business visits or tourist visitors have to apply for an ETA if they are non-visa nationals.
Super. Thanks, Adele. So we have a question about how the Fair Work Agency might operate. So the question is sort of, how is it going to engage? Will they be monitoring companies? What type of people roles will form this agency? Will they be auditing companies? Or is it just a body employees can turn to when something goes wrong? I mean, I think probably the most useful analogous agency is maybe the Equality and Human Rights Commission, which has already powers to investigate employers. And whilst we don't have details as to how the Fair Work Agency will operate in practice, I expect the way that it will typically be engaged is that either individuals will go to it to bring a complaint, so they might sort of proactively, if they're dissatisfied with the approach their employer takes, look to engage with the Fair Work Agency as an alternative, or maybe in addition to tribunal proceedings. If you have a unionised workforce, and there's general trend potentially to a bit more kind of unionisation in workforce under the new government, maybe the union will also look to engage the agency as well if they're concerned about practices in an employer. And then the other sort of way classically these sorts of agencies tend to become engaged is if there is sort of press coverage or general kind of public interest around a particular employer, that might well spark an investigation from the agency. So I think there's probably going to be kind of various routes through which the agency might become engaged. And I suppose another one may well be if there's a tribunal decision against an employer on a particular matter, potentially the agency may well monitor those and see if it's worth sort of taking something a little bit further. In terms of the types of people and roles, I mean, I suspect it will be a little bit like a sort of civil service type agency that's set up, but not too sure. But I think it's sort of, with all of these things, there's invariably kind of reasonably limited resourcing. So it might well be it's sort of something that is concerning to the employers who are kind of most egregious in their non-compliance. Because, as I say, they're probably not going to have infinite funding to pursue every complaint that they receive. Okay, so we've also got a question about what I meant when I said, companies may want to think about being more positive about the reasons why they're not able to support a flexible working request. So what I kind of, if we think about the way in which the law is likely to change, to say the sort of day one default assumption, if we take sort of as read what Labour sort of published on the topic, is that everyone will assume flexible working is possible. So what I think that probably means is that if you as an employer don't think that flexible working is possible for a particular role, you want to, in advance, kind of form your positive case for why that is not the position, rather than kind of being reactive to a request from an employee. Because at the moment, some employers will kind of wait until an employee asks for flexibility before forming a view as to whether or not it's possible to accommodate that flexibility. If the default assumption is going to be flexible working is possible unless it's not reasonably feasible, I think the onus will be on companies to be proactive, have that positive case as to why flexibility isn't possible if it's not possible, rather than waiting for an employee to make a request or to sort of bring a challenge on the topic. Okay. And then we have another question on, will the government consider a category for internships and apprenticeships? I wonder if that might be related to the single status that we are expecting to get in the next year. I don't think there's been any suggestion there will be like a standalone different category if you're an intern or you're an apprentice. I mean, at the moment, if you're an intern or an apprentice, you might be an employee, you might be a worker, you might in some circumstances be what we call like a volunteer, sort of sitting outside of those statuses. But I don't think there's an idea that there'll be kind of subcategories for those individuals. So if you have interns and you have apprentices, it might be that they fit into that sort of single employee worker status that we're going to have, rather than having the single worker status, self-employed, and then separate categories for interns and for apprentices. Okay, so we've got a few. I think we've got a question around pre-settled status. Are you able to pick that up?
Yeah. So employees who were granted EU pre-settled status but are now living and working outside the UK, will their pre-settled status be automatically extended? Will they need to apply for ETA as a visitor the appropriate time they come? That really depends on the individual circumstances. If that person has left the UK and hasn't returned for some time, and so settled status lapses after absence of 2 years from the UK, then in theory they would need to come back as a visitor. However, in practice, the Home Office system isn't that well linked up to exit and entry data from the borders. So it may be that somebody who technically would have their pre-settled status lapse will still receive a notification that their pre-settled status has been extended. It really depends on the individual facts and their absences from the UK. But in theory, yes, if your pre-settled status has lapsed, then you would have to re-enter as a visitor. And from November onwards, from March onwards, Europeans will have to apply for an ETA before they can come in as a visitor.
Super, thank you, Adele. So I think we've got a couple of extra questions around flexible working. So we've got one around, does flexibility by default also reflect on the mandatory office attendance? Yes, I mean, I think that is, I very well expect that will be the case, because at the moment, if we think about the flexible working regime, it gives individuals a right to request all sorts of changes to their working pattern, including office attendance. So whether they're working in the office or at home, their kind of hours, it's a very broad concept, flexible working, in terms of how it's currently provided for in the guidance and at law. So I think you would have to think around sort of mandatory office attendance as part of that. So if you do need people to be in the office for particular roles, again, still thinking a little bit about why that is the case. Is it that it's helpful for kind of cohesion, training, morale? Do you need that sort of office attendance because there's some sort of physicality to the role? But I think kind of giving that some thought. But I would have thought for around the kind of mandatory office attendance, that's a piece that is already being considered quite a lot by a lot of employers, because of this general trend we're already seeing in employers wanting more office attendance and perhaps some employees wanting less office attendance, and that's sort of a tension that's already coming out in existing requests. But I think, yes, it is going to be something, the kind of location, so office-based or home-based, will be part of that flexible working piece. We have a question from Marcia on whether employees have to explain or justify why they want flexible work. And I think the proposal is that no, they won't have to do that. And that is a departure from a current request. So if at the moment an employee makes a request for flexible working, they do have to give some thought and articulate in some senses kind of the impact that their request is going to have on colleagues, on kind of their work. I suspect the new arrangement will be that that's not required, because if the default is flexible working is kind of appropriate, I think it's going to be much more about the employer articulating why it's not reasonably feasible, rather than an individual employee articulating why they think it is feasible. So I think you just have to switch the onus. The onus is going to be on the employer to put its case forward, rather than for the employee to justify why they think that they want flexible working. Okay, so then we've got also a question around protection for male employees on paternity leave. Yeah, I mean, I think potentially if you have, if you're treating people on any kind of sort of statutory leave or exercising any statutory rights in a detrimental way, then yes, there are potential claims that might arise in those circumstances. And if we a little bit like sort of women on maternity leave, obviously if we have a day one right to paternity leave rather than 6 months service, that's something you're going to have to think of from the get-go. I mean, I think generally speaking, because at the moment amounts of time spent on paternity leave are less than maternity leave, it's a sort of 2-week period at the moment, albeit that might sort of change in the fullness of time. There tends to be sort of less activity around that because it's a less impactful period of leave than maternity leave or potentially shared parental leave. But yes, I think it is something that is possible. Okay, just having a little look through the questions. I think we've answered everything that's in the Q&A, or maybe just wait a moment to see if anyone else has any other question. We just got another one that's come in. Okay, so we've got another one. So to go back to the justification again, is it likely to be justifiable to be able to, for example, insist that people have to be in the office 2 to 3 days a week because of morale, team spirit, and learning opportunities? Yeah, I think potentially those are all reasons you might be able to use to justify office attendance. I mean, they're certainly some of the reasons that we're seeing clients at the moment refuse to allow full kind of flexible working requests where people want to work from home more than the employer might like, but it is going to be really case specific. So you'll have to look at whether in that particular role, in that particular team, does office attendance actually make a difference to morale, team spirit? Is it actually important for learning opportunities? Because of all of these things, you know, what you can't do very successfully is to think about like a generic principle and just apply it across the board. An employment tribunal will expect to understand why in that arrangement this is a justification. So I think they're good things to think around, but it does have to be sort of relevant to the particular circumstance. Okay. Right, I think we got another in the Q&A. Okay, so we've got another question around preventing sexual harassment. So in terms of an employer's obligation to take reasonable steps, is annual training enough, or could it be every 2 years? Again, I think this is probably going to be driven by your risk assessment and how high a risk of sexual harassment occurring you think there might be in your workplace. I mean, instinctively, I think annual training is better than biannual training. 2 years, I suppose if you're sitting there in a tribunal having to answer a claim that you've not taken all reasonable steps to prevent sexual harassment, saying that someone was trained, potentially 23 months ago on the topic, it instinctively doesn't sound great to me, but it might be if there's a very low risk of sexual harassment in the business that you're operating in, that 2 years is okay. Okay, so we just got a couple more around flexibility. So will employees be eligible to claim flexibility in the role, different office attendance, or does the employer still have the right to require the attendance based on the role? So I think this is going to be back to, so what Labour have basically said is flexibility is the default. So the kind of starting point is that all roles should be able to be done flexibly, which might be kind of hours, it might be office attendance or not, unless it's not reasonably feasible for them to be done flexibly. So I think you can still, and I think sort of Labour have been at pains to sort of make this point in the messaging around this, you can still have a circumstance where actually the role can't be done flexibly at all. It has to be sort of 9 till 5 in the office Monday to Friday. That may well be the case. But you're going to have to be able to, I think, show why that is required, why it's sort of not reasonably feasible to allow any greater flexibility. And so I think we've got maybe time for this one final question in terms of many firms are requesting employees to be back in the office 5 days a week now. So the question is, even if they succeed with these changes being implemented, will these steps be reversed? I think there is definitely a risk that firms will have pushback if they've moved to 5-day-a-week office attendance. I can very much see that this change in legislation is going to give staff a new platform to try and revisit the point. And I think what you probably want to be doing is, if you're moving to 5-day office attendance now, thinking kind of very carefully, as I'm sure you would be anyway, in terms of kind of answering requests for flexible working, as to why that is important, so why that is necessary, with a view to trying to kind of get ahead of this idea that you're going to have to show kind of in the near future why it's not reasonably feasible to allow that sort of flexibility. So whatever you can do now to justify with reference to business need, customer needs, kind of training needs, why you need that office attendance, I think getting that in place, thinking it through, providing for it now so that you're kind of clear and you're not having to slightly change your justification when the new law comes into force, that's going to be really useful. So I think that brings us to 10 o'clock. Thank you everybody for attending, and thanks ever so much for the Q&A. Hopefully you found that a really interesting discussion, and we will no doubt be in touch with mailings, etc., once we have a little bit more clarity to try and give you a better idea as to how all of these new changes are going to look in reality. So thanks ever so much. Have a nice day, everyone.